March 25, 2002, a hurriedly assembled field court-martial sitting in Karamoja publicly executed James Omedio and Private Abdallah Muhammad after a trial that lasted less than 3 hours. The duo were convicted for the murder of an Irish priest, Father Michael Declan, and 2 others. The incident raised an uproar amongst human rights activists and the legal fraternity. Section 197, Clause 2 of the UPDF gives the General Court-Martial original unlimited jurisdiction to hear and determine all appeals referred to it from divisions, court-martial and unit disciplinary committee. However, 4 years ago, the Constitutional Court ruled that trials of civilians in the court-martial was unlawful. This was the Supreme Court verdict in the case of Uganda Law Society versus Attorney General. This case contested the concurrent trial of Dr. Kizza Besigye alongside 21 other PRA suspects in the High Court and Court-Martial. International law holds that military tribunals are not competent to try civilians.
At the African Commission level, the African Union jurisprudence is very clear that civilians should not, under any circumstances, be tried in a military court because they simply cannot get justice in a military court. So the African Union is very unanimous.
Ladislas Rakafuze, human rights lawyer, says as long as the president remains its leading exponent, the court-martial will continue trying civilians.
It is appointed, first of all, by the head of command, the head of the high command, who himself is an elected president, and he uses the military to fulfill his own political objectives.
The president has the mandate to appoint the chairperson of the General Court-Martial. Ordinarily, these have been people in the service of the UPDF, people who have extensive knowledge of the army and perhaps military law.
The Shadow Defense Minister Hassan Kapsfungaro believes the court-martial is an embodiment of flawed justice system.
The military court-martial of Uganda, number one, is faulty. Faulty even to try members of the military. And then again, not suitable to try civilians.
Opio cites research conducted to prove that trials in the court-martial leave a lot to be desired. That there is no fair hearing due to the structural problems of ranking order from their superiors. That there is no confidence by the public at the court-martial trials. That the process has been reduced to compromise, whereby 80% of suspects prefer to plead of guilty to avoid the long stay of the judicial process.
Many a times, the chairpersons tend to shout instructions as opposed to have a free and fair trial.
In the military court-martial, there is no enough room for defense of human rights.
Fungaro argues that the public does not know how the court works.
The military court-martial must be dissected. It must be split for people to understand.
As hundreds of civilians face trial as a result of the recent violence in the Rwenzori region, the question is the process under the jurisdiction of the General Court-Martial legitimate? Maurice Ochol, NTV.